A very good afternoon to one and all. I am Manisha, student of BLLB 3. Take this opportunity to welcome you all on behalf of Center of Legal Studies, Geetharathan International Business School, on this Jurist Day workshop. Geetharathan International Business School was established in the year 2004. GIBS is affiliated to Guru Gobind Singh Indraprastha University, Delhi, and is approved by All India Council of Technical Education, Ministry of HRD, Government of India for its management courses, and Bar Council of India for its law courses. The institute is accredited as A grade by NAC and assessed by category A plus by Joint Assessment Committee of Government of Delhi and Guru Gobind Singh Indraprastha University. The institute conducts postgraduate courses for MBA and MBA International Business and undergraduate courses for BBA, BBLLB, and BLLB. Gibbs has rated number 2 Pan India by Times Business School survey for the year 2021. The topic for today's workshop is development in need of codification in the international law. And for today's program, we are honored to have with us the resource person, Dr. Desiree David. Dr. Desiree David is a lecturer at the Nelson Mandela University in the Faculty of Law in the Department of Criminal and Procedural Law. She is also an admitted attorney of High Court of South Africa. She currently lectures evidence and forensic evidence as well as aspects of medical law to the LLB and LLM students as well as various aspects of health law to the students of health sciences. She has also lectured the EMTs and at NMU on aspects of medical law. She has recently began lecturing in the diploma for law enforcement on evidence and pretrial procedures. Dr. Desiree David is also the principal for the School of Legal Practice, LSSA LED, Law Society of South African Legal Education and Development, in Port Elizabeth. She is qualified medical malpractice mediator and sits as a gender based violence expert in the disciplinary section for the Transformation Office at Nelson Mandela University. She was recently elected as chairperson of the South African Medical Legal Association EC branch. She is also a trainer and facilitator for Street Law South Africa and has been involved in the national training programs throughout South Africa, including succession planning for the Department for Social Development, education law for school management for SADTU, as well as field testing new materials for street law democracy for all programs. She has also contributed to a handbook on best practice of magistrates in the child justice field. Ms. Desire has delivered papers in various fields at both national and international conferences. She has also facilitated training sessions for the participants at the Global Alliance for Justice Education in 2021. During lockdown 2020, when she was stranded in Nepal, Dr. Desire served as the South African coordinator for Forensics India in India. She founded the Legal Integration Program in 2019 with the aim to mentor students to facilitate the development of graduate attributes committee involvement and fostering their personal development. She currently earns LIP at Nelson Mandela University. Ma'am, on I behalf on Center for Legal Studies, Geetharathan International Business School, heartily welcome you all to the program. Now I would like to request ma'am to take the program forward.
Thank you very much, professors, for inviting me to present to your students today and for giving me the platform to share my thoughts and ideas on the issue of the codification of international law. So if I can just start sharing my screen with you. Sorry, I'm just not able to get the thing to share. Just give me a few seconds.
No issues, ma'am. Please.
Okay. Sorry about that. I'm not at the office at the moment. I'm actually taking a few days off, and I'm sitting in a game park at present. So when we talk about the issue of international law, we're basically looking at a system of standards that regulate the relations and the interactions between countries. And these take into consideration the legal rules, the norms, and standards of sovereign states. With regard to the whole issue of codification, especially in the international law, in the International Law Forum, we are talking more about the precise formulation and systemization of the rules of international law on subjects that have already been extensively covered by these states in their domestic practices and precedents, in the doctrines that have been set out and that are utilized in the domestic forum. So as an example, for the Jewish Torah or Sharia law is basically a codification of those particular rules of practice that have been put together, have been codified, so that you have this source that you are able to refer back to. So international law is looking at basically being an independent system of law that's outside of the legal orders of the particular state. So very different from domestic law, as I've pointed out. Now, in terms of the Statute on International Court of Justice, Article 38(1), it identifies 4 main sources of international law. So you have your treaties and conventions, you have customs, you have the general principles of law, and then you have the judicial decisions and teachings that you find within that particular framework. So when you are looking at the creation of international law, you have a situation where there's one or more countries that usually meet and agree on a legal framework that would regulate the matters between these countries that have entered into this kind of agreement or this kind of understanding. If you look at international law historically, where the scope of international law was a lot more narrow than international law as we find in 2021, because it's evolved to the extent that you are also dealing with the rights of individuals. There are international organizations in addition to states themselves that form that are party to these agreements. So you have the inclusion of individuals as well as international organizations that are very vital and play a very vital role in the whole international law relationship. So international law then is not just, or is no longer just viewed as simply a collection of rules. As I've mentioned, it's evolved beyond just being this collection of rules between the members or between the parties or the states that have agreed on this, but rather it's a very rapidly developing, a very complex set of rules and influential principles, practices, assertions, sophisticated structures and processes that would include the classical fields of war, peace, diplomacy, but also extend to human rights. And we've seen in the last number of years that human rights has played a very, very crucial role and has had a wide impact and influence on international law, or the body of international law as practiced between the states. It's had an impact on economic relationships and agreements between the states, on labor issues, on trade issues, on space law, on international organizations. So there's been an evolution and there's been an expansion from international law the way it was sort of early in the 1900s to where it is in 2021, where because of the developments and the social and political changes that different states find themselves evolving through, the fact that we are more on a global stage and the citizens of the world are much more than ever global citizens, as opposed to just merely citizens of a country or a state, it was imperative that the international law rules and practices and so on have evolved to take into consideration the changes in the social, political, and global issues that have been evolving. So in the creation of international law, you have one or more countries, obviously, that usually meet and agree on the legal framework. And after the states who are parties to the agreement agree to the terms upon which the interactions will be regulated, it then is embodied in a single document. The parties to the original agreement are then known as signatories to that agreement. So where other countries wish to be part of that agreement, then they can thereafter accede to the agreement, and it then binds them to that particular agreement. So once your state parties agree and come and conclude this legal agreement between themselves, it then becomes a source of international law. So these are the rules then that govern the relationship in international law between these different parties, between the various states that are now signatories to that particular agreement. But very important to note is that once the states enter into these agreements, it does not mean that the states automatically are bound by the principles of international law. So the fact that someone has signed a particular agreement or has bound themselves to an agreement, and by someone I obviously mean a state, it does not necessarily mean that that state automatically is, or that the rules of international law automatically become binding on that state. In many cases, the countries which practice common law require that international law be ratified into domestic legislation before it gains force of law. So South Africa is one of those examples where even where South Africa becomes a signatory to these legal agreements and so on, it does not automatically mean that South Africa is bound by this. What would happen is that these laws must be ratified into domestic legislation, as the case is here in South Africa, and then they are considered to be part of domestic law, part of South African law. And we've seen this in South Africa with regard to international law, but even with regard to the Constitution, where the constitutional imperatives, in the same way that the rules of international law that we've agreed to, have then got to be included or ratified into domestic legislation so that they form part of our domestic legislation as well. In some countries, especially the civil law countries, where the legal system is more of a civil law legal system, where international law is deemed binding on that country when it's signed to or acceded to without requiring that ratification. And one of the issues that I will be addressing further on in my presentation is to look at the merits and demerits of having a codification system. And so obviously there are advantages and disadvantages to actually codifying these international law principles or international law. But you can see that the common law countries and the civil law countries have a somewhat different way of dealing with the issue of ratification and whether ratification is required. When you're looking at international law, you're looking at, or if we can summarize very, very quickly, an independent system of law that operates outside of the legal orders of the state. Okay. So, for example, you have the UN General Assembly. It has no power to issue binding laws as such, even though some of their resolutions may well appear to be a type of legislation, or they take the appearance of legislation in a lot of cases, but the resolutions merely serve as recommendations. Obviously, so for example, in the criminal law field, for example, if you are electing new judges to the International Court of Justice, the jurisdiction of that court is founded on the consent of the states themselves. So jurisdiction is granted on that court with the consent of the states that bind themselves to the different agreements and so on. You don't have an international police force, for example, that is going to enforce the directives, for example, of that particular court. You don't have a comprehensive system of law enforcement that is going to give effect to the orders of that particular court. So a lot of those, as I've mentioned, resolutions will serve as recommendations, and then those will be dealt with by each of the states themselves with regard to ratifying them into existing or new domestic legislation, as well as incorporating it into the law of that particular country. So you have the United Nations Security Council, for example, that may authorize the use of force to comply with decisions only in the case of a prior act of aggression. So there's got to be an act of aggression before the UN Security Council will authorize the use of force in those particular circumstances. And then when you have the UN Security Council making these resolutions as well, you have the 5 permanent members of the UN Security Council. You have China, you have France, you have Russia, you have the United States and the United Kingdom that may choose to exercise their veto power because as the permanent members of the Security Council, they are vested with that veto power. And we've seen very practically in the last few years where certain countries like Russia, like China, for example, have exercised that veto power when it comes to certain decisions or certain resolutions being put into effect or taking effect. So obviously, you have that needs to be considered. So with regard to the development of international law in recent years, as I've mentioned, international law is ever changing. It is evolving as the rules and so on are developing. You find international law is developing in order to keep up with changing social, political changes all around the world. Once again, as we have evolved in the evolution of the world with regard to the different states are not so insular anymore, as more and more individuals are becoming more global citizens, as the countries become more globalized in their trade, in their in other relationships, whether it's political or from a financial and trade point of view, it becomes necessary for the rules, for the system of rules that governs the relationships between these different states to evolve, to take into consideration the relationships and the new set of circumstances that needs to be provided for. Now, there are international agencies who've taken up the mandate of being at the forefront of the development and codification of international law. You're familiar with the United Nations, which through its General Assembly plays this particular role. If you look at Article 13 of the Charter of the United Nations, it basically states that the General Assembly is mandated to encourage the progressive development of international law and the codification of international law. The United Nations Office of Legal Affairs assists the General Assembly to fulfill this particular mandate, and as such, the International Law Commission was created in order to fulfill this particular mandate. You also have the establishment of legal committees and diplomatic conferences, for example, to support this particular mandate. Now, in the arena of international law, there are very many different areas, such as environmental law, which is one of the key talking points from an international law perspective. You have human rights, the area of human rights, which is developing or which must be developed to take into consideration the fact that there are wars and conflicts and so on that are springing up all around the world. International law needs to deal with areas such as trade and so on. And therefore, you have a number of developments that have been made in the recent years. So I've included in this presentation just a few of those developments that we have seen. So you've seen with the advent of the COVID-19 pandemic, for example, the international courts and arbitrators chambers have had to adapt to the COVID-19 pandemic by ensuring that any proceedings that they have that come before it are compliant with the WHO guidelines that deal with COVID-19. Your United Nations Intergovernmental Panel on Climate Change, for example, releases a new report or releases reports on climate change. And these reports, as they are released, have to be taken into consideration the very significant strides that were made in creating key environmental instruments, such as, for example, the Kyoto Protocol, the Rio Declaration, the United Nations Convention of the Law of the Sea. If you look at the European Commission, they launched proceedings against the United Kingdom and Finland for failing to sign an international treaty that effectively limits EU member states from entering bilateral investment treaties with each other. In the North Americas, you had the United States of America, Canada, and Mexico, who entered into a new trade agreement with which repealed and replaced the North American Free Trade Agreement. And then you had the UN Secretary General Antonio Guterres, then who renewed calls for vaccine equality. Once again, against the backdrop of COVID, which basically means that the wealthier countries should not hoard vaccines and ensure that the poorer countries, which do not have the rights and the capacity to manufacture these vaccines, are given equal access to vaccines manufactured in these particular countries. So I think a lot of these things that I've mentioned in here, you students will be familiar with, because these would have been part of your studies, part of the content or the material that you would have come across in the course of dealing with your studies in other courses. So there's still no, just in the context of COVID, there's still no international agreement or guidelines on mandating travelers to be vaccinated against COVID-19, for example. But what you find is that individual countries are opting to adopt their own rules regarding the vaccination of people who are traveling into their countries. So for those of you who are thinking about travel, certain countries have closed off travel to unvaccinated individuals. Certain countries will let you in without going into quarantine if you've been double jabbed, if you're fully vaccinated. But if you're not vaccinated, then you have to go into quarantine for 10 days or 14 days before you can enter that country. There's certain countries that are on that red list where travel between certain countries are not permissible. So while there is no international agreement, for example, or there's no uniform agreement with regard to what is required of a traveler and what countries you can enter into and so on, you have the individual countries that are developing or adopting their own rules, and some of them obviously are or can be perceived as unfair. So you would have some individuals who maybe are not able to see family members and so on because they are restricted from traveling because of the particular country's rules and so on with regard to travel from certain countries. And you find it, and this is a very hot topic in South Africa at the moment, where individual schools and companies are adopting their own policies with regard to vaccination. So there's a huge debate in South Africa about having vaccinations made mandatory in the workplace, for example, you would notice or you would see what's happening in Australia, for example, where the protests and so on have turned somewhat violent with regard to the COVID restrictions that are being adopted by that particular country. You have certain countries where frontline workers, like healthcare workers, have been now mandated to take the vaccine. And you have a situation where the result would be to take the vaccine and have a job, or refuse the vaccine and potentially not have a job. In South Africa, I think that the position is, and especially with regard to schools and universities in this country, there is still a choice with regard to taking the vaccine or not. However, certain workplaces, certain employers, and there are discussions with regard to tertiary institutions like the university, for example, with regard to whether making mandatory vaccinations is advisable in the circumstances. And obviously, even though you can see that this is a global phenomenon, the pandemic is a global phenomenon, but we still don't have any uniform agreement or guidelines with regard to how that is being dealt with. So as it is at the moment, each state, each country is responsible for putting into place its own protocols, its own procedures, its own policies with regard to how to deal with travel, for example, how to deal with lockdowns and restrictions from work and curfews, and whether those things can be mandatory as well. So in each, with regard to COVID, but with some of the other things that I've spoken about, it's evident that there is an underlying agreement that either was concluded or that is necessary to regulate the matters that have arisen. Very much a lot of with the whole COVID issue, a lot of the discontent, I think, comes from the fact that obviously it's seen by some as an infringement of rights, and that is debatable whether it is or not. But also because there is no uniformity with the way in which it is being dealt with. So, like I said, it is a global pandemic. It is, but each state is being required to deal with it in its own way. And so, a lot of the discontent comes from the fact that it's the luck of the draw with regard to either where you live or where you happen to be at the time that the rules get put into place, which it's argued is not a desirable situation, because obviously some countries are reacting to this in a harsher manner than other countries do. And the argument is that if there was an international agreement or between the states, or if there was some uniform guidelines with regard to vaccines, with regard to travel and so on, then there would be not this disparity between the way in which different countries, different states are reacting, and the procedures and the measures that they are adopting when it comes to dealing with these. So if you go through the next part of the slide, I refer you to obviously the problem between the UK and Finland. So what happens in this case is that the EU has a legal framework that regulates the interactions between countries who are members of the EU. And the role of that law is to basically ensure that all members comply uniformly with provisions that concern entering bilateral investment treaties. And obviously the UK at the time and Finland potentially infringed on them. So the body, the EU Commission, that was bestowed with the powers to investigate the matter, and if it concludes that the law has been infringed, then sanctions can be imposed, because that would be one of the means of ensuring enforcement or compliance. So obviously, this would be one of the mechanisms that can be used in enforcing compliance of the decisions of the EU. So you can see that if you are considering international law, it has the following features, just to summarize quickly. It's a body of laws created by countries, commissions, which comprise the representative of those countries. The legal framework is created through agreement. And where the provisions have been infringed, then there must be a party or a person who can institute action to ensure compliance with the international law provisions, because it does not make sense to have this body of law or this body of rules and so on that is supposed to govern relationships and relations between the countries. And it doesn't make sense if there is no means of ensuring compliance, because then there would be no reason to comply with those rules if there are no penalties, for example, for non-compliance. And as I've mentioned, sanctions, when we've seen quite frequently the imposition of sanctions as a tool of enforcement and compliance being imposed on the party who has infringed those international provisions. So the largest problem facing international law is that in most cases, as I've mentioned, compliance is voluntary in a large number of cases. So you have no mechanisms or very few mechanisms or limited mechanisms that can be used to enforce compliance with the legal decisions or with the imposition of sanctions. Now, you have the international courts and you have the arbitration forums that are set up, but they are plagued with a lack of enforcement mechanisms. And this is one of the reasons why international law is very often brandished as being weak, because in a lot of cases, there is no formal or uniform body in order to follow through and ensure that compliance with the sanctions, that there is compliance with the sanctions that have been imposed. And this is one of the biggest reasons or criticisms of these forums, is because there aren't the necessary enforcement mechanisms, or they aren't effective enough, or they are just lacking. So if sanctions are imposed, for example, who then ensures that there is compliance? And what are the further penalties then for non-compliance of those particular sanctions? In some cases, other countries can adopt political and economic sanctions to try in that way to compel a state to comply with sanctions. But as you may have seen, if you are a follower of politics and events of a global nature, where you have political interests and financial interests in conflict or that need to be protected by certain states who are also signatories or who have also agreed to those rules and regulations, then the furtherance of political interest may not make one of the parties that amenable to try and compel the non-complying state to comply with sanctions. And so this obviously, because the different states have different political interests, have different financial interests or economic interests with regard to the different relationships that they may have with the different states, it becomes a very complicated way of trying to ensure that there is compliance, because in addition to, it's not as simple to say that country A is in breach and therefore we impose sanctions. Country A is not complying with the sanctions imposed, therefore country B, country C adopt political and economic sanctions against country A to try and make them comply. But you may have very conflicting interests involved with the other countries, which may not be in their interest to go further and try and impose further sanctions, whether economic or political. And so then the whole enforcement procedure gets seen as being weak because it does not really have any teeth. So you have a country that's not complying with sanctions who's going to step up and do something about it, because as I said, there isn't this global policing body or law enforcement body and so on that can then step in. So it's very much up to the will of the individual states to determine for themselves how far or not they are going to be willing to go with regard to trying to compel a delinquent state to comply with sanctions. So the failure to develop a mechanism to ensure compliance has not really been addressed effectively in international law. And clearly, until this is addressed, international law will continue to be seen as weak because obviously it's still very much dependent on the will of the states with regard to what steps, if any, may be taken against a state that is or that finds itself in this position. So to go back to the very first portion of my presentation, I talked about the issue of codifying international law. Just to reiterate, we said that codifying international law involves taking sources of law and creating a written record of international law. And obviously, one of the huge advantages of codifying international law is that of uniformity. So if you codify international law, you basically are ensuring that there is a uniform system of law that applies to all countries and legal subjects in terms of international law. So you have it there. It's a uniform system. It applies then to all the countries. And there is no, because it's been codified, you have this uniform system. All legal systems require one form or another of uniformity so that the laws can be universally applied, so that the laws are stable, so that you don't have a situation where the laws can be subject to change willy-nilly without undergoing a proper legal or political process to actually change it. And so the consensual nature of international law prevents it from having these features. So if you have a uniform system of international law, one of the things I think that sometimes is not considered is the legal, the political, and the cultural differences in a legal system. So obviously, if you're looking at international law, you're looking at a whole number of countries. You are looking at different legal, political systems, but also cultural differences within a legal system. And I think you in India will be more aware than most of how cultural differences within a single country, within a single legal system, can have such a vast impact on the manner in which the law is applied, or the factors that get taken into consideration to make sure that, first of all, that cultural that there is respect for cultural practices, and also that there are not rights being violated in applying the law, especially where you have the kind of cultural diversity that you have in a country like India. We have that kind of cultural diversity in South Africa as well, where in addition to the different race groups, we are looking at a whole number of different cultures within the different race groups that we had, the race groupings that we had historically. And obviously, the problem that multicultural societies land up with, as you find in India and that we have in South Africa as well, is that from a cultural perspective and with regard to custom and practice and so on, the laws that are applied have got to take into consideration these cultural differences and practices and so on. And obviously, it's problematic because within the country, as well as between the different countries, all of these, or you have these vast differences. So, for example, by Western standards, we may consider some aspects of Muslim Sharia law as being or as being not lawful, or as being not sanctioned by the legal process. But our constitution also tells us that we have got to be mindful of custom and so on. So there's always this balancing act that needs to be carried out. And obviously, if you are looking at one single uniform system of international law, that you have to have or take into consideration the political, cultural, and the legal systems that operate in the domestic law environment, because obviously your international law provisions have got to be cognizant of what happens in domestic law practices. Customary international law, which is something a little different, obviously has played a role in creating a uniform legal framework for the different countries. But this clearly is not without its own problems. One of the other advantages of codification is that it ensures access to the law. I think especially in countries that have like in India and South Africa, where you have access to the law being affected by things like illiteracy and financial means and so on. You want to be able to ensure that parties who require the law can have easier and better access to the law. So in some cases where a country concludes a treaty, but then fails to adopt a similar provision in terms of domestic law, it would then be easily accessible for a party whose rights have been infringed to have access to the law, to international law, for example, in order to vindicate their rights. So that could be beneficial in circumstances where the domestic law does not fulfill the certain obligations in its domestic legislation, where you have then an individual who has a right of access to the rules of international law in order to vindicate their rights in those circumstances. And codifying the law also ensures that the laws are preserved and that they are stored and that they can be accessed by the parties who require it. If I can go very quickly into the disadvantages of codifying international law, obviously, if you have a disagreement between the countries or states, in order for codification to take place, your individual countries must agree to undertake must agree on how they are going to make provision for these laws and how they are going to be expressed. In many cases, countries, as I've mentioned, will have different political interests. And so there are a number of factors that could prevent cooperation towards codification of international law. So you may have, for example, a move to codify certain aspects of international law. If you have one particular country who has certain political interests or political interests that may be at odds with the other countries involved, you have a situation where there could be a lack of cooperation, or there could be moves to use influence to prevent other countries from cooperating. And obviously, this is problematic, because if you have this kind of disagreement, then you are not going to make any progress with regard to codifying those particular laws. And when you have multiple parties involved, it's very difficult to have all of them to consent to everything in its entirety. Because of the different interests, because of the different differences in domestic laws, because of different religious, cultural, political issues, and so on, where you have a number of parties coming together to try and reach consensus, it's going to be very complicated and it's going to be difficult. And in a lot of cases, very time consuming, where there is no, at the end of the day, there is no consensus. Because even though the multiple parties are attempting to reach an agreement on something, remember that each of those parties are looking out for their own individual interests as a state or as a country themselves. So you don't want to bind yourself to an agreement that's going to be detrimental to the interests of your country or the people of your country. So where you have multiple parties involved, it's sometimes very, very difficult to have them all consent to the process. And this will delay or prevent the codification system from actually happening. And then you have the rigidity of a codified system of law. Where laws are codified, then they become very rigid and they don't necessarily reflect the changing needs of a legal system. And so in a lot of cases, it would appear to remain easier for the law to remain unwritten, because if it is written, then it has to be rewritten if it changes. So there is that aspect to consider, that and especially if you have to go through a very formal process, like in domestic law, where you have to go through the parliamentary process, for example, to get a law rewritten or to have an amendment or whatever, then it becomes difficult to be able to take care of it that way. But there are, having said that, there are existing statutory interpretation mechanisms that could remedy this particular situation. So it's not a it's not something that will present too much of a stumbling block. Also, you may have the situation where there are too many laws to codify. So, especially in international law, because there are so many different matters between so many countries on needing to be regulated, because these countries are located in different geographical areas, because they have various interests, sometimes opposing interests, and so on. The laws may involve different technical matters, which may be very many, and this may then complicate the codification process. And then you also have the question of who will perform the codification process. In domestic law, you have a political process which is involved with the enactment of the different laws. In international law, you don't have this democratic and political process that is in place where a certain determined mechanism is in place that can undertake the codification process. So is it going to be political representatives from every country that are going to drive the process? Is it going to be private organizations that will undertake the political or the codification process? If it is private organizations, are you potentially looking at conflicts of interest, or is there bias that will be reflected by involving them in the codification process? So in a situation where you don't have a specific or a designated person or representative or body from each country, then there are all these issues that could stall the codification process or result in a flawed process when it comes to codification of those laws. So it would appear that there is now urgent need to codify international law. The reason for this is that there are a number of underlying issues that need to be resolved domestically as well as at an international level before the codification process can begin. One of the things I stressed is that, or one of the things that we looked at is the enforcement process. And if you have codification, obviously it would facilitate the enforcement process and make international law uniform, more accessible, and have more definite enforcement processes in place. And the process would make it the responsibility, make the enforcement the responsibility of certain individuals, organization, and so on. But the failure to have an enforcement mechanism, as I've mentioned, is something that gives international law its very, very weak status. And so it would appear, and it's argued, that this failure to have the enforcement of international law and the resulting view that international law is actually very weak as an instrument of law seems to be a greater obstacle to the whole international law process than the fact that it is not codified, or the problems that come across with regard to actually undertaking the codification process. So, it would appear that from a priority point of view, rather than address the issue of codification, it should rather be to address the enforcement and the so-called or the perceived weakness of international law, rather than the actual codification of international law that should take precedence. So that brings me to the end of my presentation. I've just included at the end of the presentation, which I'll make available for you, some links for additional reading on this topic, which is at the end of the presentation. And thank you for your attention.
Thank you so much, ma'am. You're truly an epitome of knowledge. It was extremely valuable to be a part of this session. Ma'am, may I have your permission to take up a few questions from the audience they would like to answer?
Yes, thank you.
So, whosoever has any question can raise their hand or just speak up while unmuting them. Ma'am, I have a question. Someone texted me that. What are the effectiveness of UN resolution and can it be termed as legislation?
Okay. Although it has the appearance of being legislation, I don't think that it falls within the definition of what legislation is, because a lot of the resolutions seem to be or appear to be more recommendations. And if you come back to the question of enforcement, those resolutions have been taken and so on. But what happens to a party who is not in compliance? Are there sanctions imposed? And if that is, what is the will of the other states to make sure that that the sanctions are effective, or that the wrongdoing party is being brought to book for that? So if it was to be looked seen as being legislation, then as with all legislation, there are sanctions, there are penalties for non-compliance. There are certain procedures that need to be put into place on non-compliance. So, for example, to give the party a certain amount of time to comply. If there's non-compliance, then these would be the penalties, and specific methods and processes and procedures in order to effect those penalties. So with the resolutions, you don't always have a very effective way of ensuring enforcement, of ensuring that the sanctions against the member who is in violation of the resolution, or who is guilty of some kind of misconduct. Coming back to the whole issue of the perceived weakness of international law, this is or the inability to ensure proper enforcement and compliance with the sanction is something that is very evident with regard to the resolutions. But with legislation proper, with an effective piece of legislation, you should not have that shortcoming when it comes to that particular aspect. If you think about it in a criminal law kind of setting, if someone's committed a particular crime, all the elements of that crime, then if he's found guilty, there are certain then penalties involved for the person where there has been a guilty a conviction, and there are mechanisms and what is the word? There are mechanisms in place to ensure that the guilty party is punished or can make reparations or whatever. And enforcement is a problem with some of the resolutions. I hope that's answered that question for you.
Yes, ma'am. Thank you so much for your answer. And the second question comes here. What would be the consequence if a permanent member of the Security Council refuses to recognize order of ICJ?
Sorry, I didn't get that last part.
ICJ, International Court of Justice.
Mm-hmm. Okay, so once again, as I pointed out in the earlier part of the presentation, in a domestic setting, what you have is a police force, for example, that would be in a position to follow through and to enforce or to effect arrests and so on. You don't have that kind of thing. And as we've seen with a few very high-profile matters, there was not much confidence in those procedures because of a lack of follow-through once that particular body reached or concluded its hearing, its sitting, its investigation, and so on. So in theory, these are all wonderful institutions. But once again, if you go back to the ability to follow through for the person who is waiting for justice to be done, if you put it that bluntly, it almost seems like there is no justice when there isn't where there aren't the mechanisms and the processes in place that can give effect to a judgment or a ruling and so on. So, this is not to say that these bodies and these forums don't have any value. They certainly do have a lot of value in the international law arena. Especially where domestic law is not in a position to, or does not have the political or the will to actually follow through with that. And so when you have these international tribunals and fora and so on, you have individuals who may feel that rights have been infringed, or where there is not political will domestically to attend to that. You have these international tribunals and so on that can address the issue, which is wonderful that individuals in different states have this resource that they are allowed to use and that they may approach. However, once again, it is a problem because a lot of it depends on the will of the states and the organizations and so on. So this is a problem, and it is why the perception is that international law is weak in some instances with regard to some of the matters. Thank you. Do you have any more questions?
Yes, ma'am, we have one more.
Okay.
Can international law treaty can directly applied by the domestic courts with any domestic law? If yes, what country has that legal mechanism?
Okay, so depending on the kind of legal system that you are dealing with, as I've mentioned, a country like South Africa and most of the common law countries would require the international law principles to form part of the domestic law. And then we talked about the common law countries that do not require such ratification. So I'm not able to tell you offhand which you have. And I think it also depends on your domestic law and what is permissible in terms of the domestic law mechanisms that you have at your disposal. But certainly you've had, because I'm just thinking with regard to some of the, and I'm just thinking in terms of DNA evidence, for example, where you've had domestic courts in the UK, for example, that have made certain rulings with regard to DNA evidence. This was sort of early in the 2000s, where the accused persons in those cases felt that the highest courts had pronounced on those matters, but those individuals approached the international courts for resolution of the human rights issues, where the domestic legislation was applied. And the question of DNA evidence was in favor of the Crown, and the individual then approached the International Court of Human Rights with regard to the human rights, potential human rights violation with regard to the taking of DNA evidence, the retention of DNA evidence, is thinking specifically of the one case where one of the applicants to the court was a minor. And obviously, in that situation, the court had jurisdiction to hear that particular matter. And the matter was brought on the basis of a human rights violation. And so there you had the international law be applied, even though there was domestic law that was applicable, where the court considered specifically the rights issues of the applicants to that court. So you had a situation where, even though there was provision in the domestic law, the international courts applied international law principles in coming to a decision on that particular matter.
Thank you very much, ma'am, for clearing our doubts with such ease and kindness. Although this questionnaire session could go for long, but due to time restrictions, I must conclude the session here. I thank our honorable guest speaker, Dr. Desiree David, for sparing her precious time, and hope your words of value are a life changer for many. Thank you so much, ma'am, and all who are present here. Have a nice day. Stay safe.